I want to ask about sort of a question about the whole of government approach to this issue. And it really builds from the Canadian Bar Association letter to us where they state that, and I quote, Bill C-42 will disproportionately impair the privacy and personal security rights guaranteed by the Canadian Charter of Rights and Freedoms. They don't ask it as a question, make a statement.
Madam Chair, thank you. It gives me great pleasure to introduce Bill C-42, which once in force will create a public and searchable beneficial ownership registry of federally incorporated companies. This registry will be a powerful new tool in the fight against financial crime, the enforcement of economic sanctions, and more generally, the protection of all Canadians. Madam Chair, unfortunately, there are bad actors who will use corporate vehicles for illicit purposes. Specifically, anonymous Canadian shell companies can be used to conceal the true ownership of assets and launder the proceeds of crime, including corruption, fraud, drug and human trafficking, and other offenses that seriously harm our communities throughout the country. And therefore, we have to act decisively and quickly, and that is what we propose to do with Bill C-42.
To a robust and effective regime that will combat money laundering and tax evasion, improve Canadians' trust in the marketplace, and make Canada a leader in corporate transparency. To catch those bad actors, law enforcement, tax, and other authorities need access to accurate and up-to-date data on the individuals who own and control corporations in Canada. The amendments proposed in this bill, C-42, will require CBCA corporations to collect and send additional information about their individuals of significant control, namely residential address and citizenship. Bill C-42 will also require that Corporations Canada make publicly available a portion of this information. It is really important to note that individuals will continue to have the option to provide an address for service, and that when they do so, it is that later address that will be made public. Creating a free, public, and searchable registry of beneficial owners of federally regulated Canadian corporations will increase corporate accountability, and I think will improve public trust in corporate institutions in our country. La citoyenneté, tout comme la date de naissance.
Citizenship and date of birth will be accessible for authorities, but it will not be public in order to protect the privacy of Canadians and to prevent any fraud and discrimination. The bill also introduces exemptions for certain at-risk individuals, and these exemptions are necessary in order to guarantee that it's charter compliant, that the provisions are targeted and limited. Law authorities will have full access to this data.
Proud that the bill received the unanimous support of the House of Commons. I must tell you, Madam Chair, it's not every day that you see that. But it sent a very strong signal, I think, to everyone in this country that we are serious about doing something. There is widespread recognition of the benefits that the new registry will bring to Canada. And after significant study and deliberations, all parties support the specific modalities that have been put forward in the legislation. These modalities include a charter-compliant balance of privacy protections, a strong compliance apparatus, including both civil and criminal remedies, multiple measures to ensure the accuracy of the data in the registry, provisions to ensure the interoperability with provincial, territorial, and other international registries. And I would like to add to the remarks that this is really key, the interoperability, because if you want something that is meaningful, it needs to be interoperable, not only with other jurisdictions in Canada, but also internationally, obviously. And while we're doing that, it's going to leverage existing reporting mechanisms in order to reduce the additional administrative burden on corporations to the maximum extent possible. And that was really something that was clear to me coming from a family of small and medium-sized business. You want to make sure that whatever you do is not unduly increasing the reporting requirement for businesses. La création de ce registre représente, je pense,
The creation of this registry represents an important milestone in the government's multi-pronged approach to tackling financial crime, which will serve as the foundation for our continued efforts over the coming years, Madam Chair. For the benefit of Canadians watching us today, I hope that your committee and the Senate will recognize the importance of this bill and will ensure its speedy passage, enabling the registry to be put in place as quickly as possible.
we must stop those who want to use Canada as a place to incorporate shell companies and rather provide law enforcement and the public new tools to deter abuse of our corporations and reinforce trust in the Canadian marketplace. With that, Madam Chair, I'll be more than happy to take questions from you and from members of the committee.
I want to consider how this fits in with changes to our the privacy protections of Canadians under C-27, our Privacy Act in terms of how the Government of Canada behaves, and provincial privacy legislation. And then you also then look at related legislation like PCML-TFA and FinTrack, different organizations across government. There is really a need for a whole of government perspective on this legislation. So could you speak to, and perhaps Mr. Sean wants to step in as well, about how you have future-proofed this legislation to manage those complexities that certainly at this point in time the Canadian Bar Association is pushing back on? Thank you.
I love the Canadian Bar Association. I've been a member of the bar for I don't know how many years. But I would say respectfully to the colleague of the bar that we have consulted widely. And I think, Senator, first of all, thanks for your leadership and thanks for your question, because it's a very relevant question, especially when we've seen what happened in Europe. So we've been informed in our deliberations and choices, to go back to senators, the different question we had, as to what would be made public. And we have also consulted with the Privacy Commissioner to make sure that this would be charter compliant. So we've been very careful on one end to make sure that law enforcement would have the tools, but that we would not find ourselves in a place. In our opinion, and I would say the opinion of the House, this is charter compliant, and we have taken all measures necessary to make sure that we respect the privacy. And I'll give you an example. For example, someone could have the address for service, not their residential address. Minor don't have to provide their name. So there's a number of things that we have taken into account to protect what people would say is their privacy, whilst at the same time having the public policy objective that we have. So, you know, there's a number of exemptions also that people could say they would be targeted if their name and residential address would be there. There's a number of exemptions. Like I said, minors are excluded as already. You can have an address for service of process. So I think there's been well thought through, and I always respect the bar's view on that. But the work we've been doing is really to strike the right balance. And I think, you know, we've been informed, like I said, with what happened in Europe, and therefore that's why we decided to put the line there.